Hi all, welcome to ReguLaw, the CMRA podcast on regulatory law, led by Andrew Pavlovic, who specialises in SRA professional discipline and regulatory investigations, and hosted by me, Liz Pearson, jack of all trades and particularly interested in regulatory law. In this episode, we'll be exploring the issue of privilege in regulatory proceedings, and in particular, the SRA's contention that it can compel the production of privileged correspondence between a solicitor under investigation and his or her client. We'll also discuss the SDT case of Joel Woolf. And today we're joined by Adam Sher from Fountain Court Chambers. Adam has a broad commercial practice, but most relevantly for our discussion today, he has a particular interest in all aspects of legal professional privilege. Adam's been involved in a number of important decisions in this area, and he frequently speaks and writes on the topic. So let's get started. Adam, do you want to start us off just with a summary of legal professional privilege? A brief one, perhaps?
Certainly. So I think legal professional privilege can probably be best thought of as a special form of confidence, which is specific to lawyers. So it's more than a regular duty of confidentiality. So as I'm sure as most of your listeners will know, in the disclosure context in litigation, the fact that a document is confidential is not an answer to whether you have to disclose it. You can't withhold it simply on the grounds of confidentiality. You can ask the court to exercise a discretion to do that, but you don't have an absolute right. Now, in contrast, legal professional privilege is like a super form of confidence where it is absolute. So say for some very limited exceptions, which I know we're going to touch on later, a party cannot be forced to provide privileged material either to the other side or to the court. Now, legal professional privilege is generally said to have two commonly called subheads, legal advice privilege and litigation privilege. I think for what we're discussing today, it probably doesn't matter. We don't need to distinguish between them. We can probably just talk about privilege. But the paradigm case, as I'm sure we all know, is a lawyer-client communication made in the course of a lawyer's engagement. That is the paradigm example of a privileged communication. And just briefly to say something about the rationale, because I think that's important for the discussion. The idea behind professional privilege is simple. It's that if we have a system governed by the rule of law, it is essential that people can go to lawyers and make what the cases often talk about, making a clean breast of it. So the idea is you can tell the whole truth to your lawyer and you are secure in the knowledge that the lawyer can't ever say what has gone on and no one will know, and that will encourage you to get the right advice. So before I stop talking, I was going to make two very brief points. The first is, and this is again, I think, critical to the discussion we're going to have, it's the client's privilege. So although it's a legal professional privilege, it's the client who has the privilege, and only the client can waive it. And there will definitely be cases where the lawyer has his or her interests are very much to waive, to produce the material. But if the client doesn't want to, the lawyer can't. Doesn't matter how much they would like to. And the second point is that, as I mentioned earlier, privilege is a fundamental absolute right. And what that means is there's no balancing act. So if you have a document which is privileged, the court doesn't weigh up the interest of disclosure versus the interest of preserving it. The privileges has to be respected. And one of the very few ways it can be overridden is by statute, because under English law, Parliament is supreme, so Parliament can do anything, including overriding privilege. But because it's a fundamental right, the courts have taken the view that Parliament won't do that lightly, and you therefore need very clear words. So I'm not sure that counts as a very brief introduction, but I hope that sort of sets the ball rolling.
I think for counsel, it's pretty solid. So thank you, Adam. We'll turn to Andrew then. So we've got a concept of privilege, but how does that arise in SRA investigations? And what's the SRA's position regarding its ability to review those privileged communications?
Yeah, so I guess the first point is, as Adam's already said, the privilege belongs to the client. So where the client is the person that's made a complaint about their solicitor or reported their solicitor, they've either expressly or impliedly waived that privilege. So that we don't really have an issue there. But obviously that's not the only way that complaints come to the SRA. The complaints can be made by the other side or the other side solicitors or from a completely different third party like the press. And then when the complaint is made there, the SRA needs to get to the bottom of, well, what did the solicitor advise his client, his or her client? That's where these powers that they say they have potentially come into play. And they've got two pieces of guidance which reference this. The first is their gathering evidence and investigations guidance, and they say there quite plainly and robustly that they are entitled to see and use privileged documents for their regulatory purposes and only for their regulatory purposes. And that's an important sort of point which Adam will probably come on to later. And then you've got their self-reporting and notification guidance. So this is advice to firms and individuals when they have to report matters to the regulators under the self-reporting obligations as to how they might do that. And if they want to report or provide something to the SRA that's privileged, the SRA's guidance is firstly try and obtain client consent. But secondly, if you can't obtain client consent, invite us to serve a notice on you, and that service of that notice will enable you to provide the privileged material. So that will sort of get you out of the problem that you may otherwise have in providing the material. And the notice that they're referring to there is a notice under Section 44B of the Solicitors Act, which gives the power of the SRA to request documents for various reasons, but the most obvious one is where it's necessary for the purpose of investigating where there's been misconduct by a solicitor. So effectively, if you think you want to disclose something to the SRA which would be privileged, tell them what it is, or give them an indication. We have these documents, category of documents. They might then serve a notice, and then according to the SRA, you're in the clear then to be able to provide them.
Okay, so that's the regime in the abstract. I'm hoping you might have a case to help illuminate that and how it operates in practice.
Yeah, so I thought it would be interesting to illuminate this discussion by reference to a case, and the one I selected was the case of Woolf, which was a 2023 case where a solicitor was suspended for 12 months for acting without integrity and trying to take unfair advantage of an elderly tenant. It was a landlord and tenant matter where the solicitor had served notices in a way to sort of trick the tenant into thinking he only had to respond to one notice where there were actually two. And the SRA's case relied heavily on the solicitor's advice to his client, where he actually openly described what he was doing as a trick, a ruse, sharp practice, etc. The tribunal's decision doesn't actually say how the SRA got hold of those documents. So it could be that the solicitor's clients consented to their release. There's no obvious reason for them to have consented because they weren't the person making the complaint, but they could have consented. Or the SRA could have served a notice under Section 44B, as I just mentioned. And I thought that it was an interesting one to discuss, because I guess it raises the question, well, if the client hadn't consented and the SRA didn't have this power, which maybe they don't, according to what Adam's about to get onto, how would they have brought that case? How would they have prosecuted that case?
All right, so you're alleging that Adam's got a different opinion to the SRA. Adam, do you want to take this floor and explain what's going on?
Sure. So I think the starting point is that, as Andrew's explained, the SRA's position that they can do this is very clear. I think for my part, what is less clear is why legally they say they can do that. And I think there are two possibilities that might be being referred to in the guidance that Andrew's pointed to. The first is a very well-established exception to privilege, which is what I mentioned before, which is the right of Parliament to pass primary legislation which overrides privilege. So there's absolutely no doubt that legislation can do that. Examples of it happening are relatively rare, and that reflects the fact that privilege is seen as a very important fundamental right. The test for statutory override is very demanding. So essentially what it requires is either the statute expressly says that privilege is overridden, that, for example, if it said the SRA can obtain documents notwithstanding the fact they're subject to privilege, that would obviously be perfectly clear, there'd be no debate. There is another possibility, which is known as necessary implication. And that is a very stringent test. It only arises if the legislative provision would be rendered completely inoperative or its objects largely frustrated were the privilege allowed to operate. So it is a very, very high threshold. And again, that fits with the idea that if there is a fundamental right involved, you would normally expect Parliament to deal with it expressly. And it's only if it's just so obvious that the whole regime couldn't work that the courts will find that override. So that's one possibility. The second possibility is slightly more interesting, and that is the fact that, that there is a doctrine which historically has been referred to as the no infringement principle. I'll just try and explain that briefly, just to put in context what this involves. It's an alleged principle, emphasis on the alleged, which comes from effectively a few lines of a speech of Lord Hoffman in a case called Morgan Grenfell in the early 2000s. Now, that was not a case about solicitors' regulation at all. But in the course of the argument, there was some discussion of an old case, the 1969 case called Parry Jones and the Law Society. And that was about whether the Law Society could access privileged materials back in the 1960s. Now, the law of professional privilege was very different then. It was many years before it was recognized as a substantive right. Now, Lord Hoffman, in this speech, says he doesn't like the reasoning that is in this case, but he thinks that the result, which was that the Law Society could access these documents, was right. And the explanation he gave for why it was right is the source of this no infringement principle. And basically what he said is that the Law Society didn't want this material in order to use it against the client. It was interested in the solicitor's conduct. And because it wasn't interested in using the documents against the client, he said there wasn't really an infringement of the client's privilege, or if there was an infringement, it was only a technical one. And there have been some subsequent cases which referred to this principle and applied it, although none of them, it was never the sole ground. It wasn't part of the ratio of any of these decisions, but there were some subsequent cases which talked about this no infringement principle. So that is the other possibility of what the SRA might have been referring to. And one thing that possibly weighs in favor of that is, as Andrew mentioned, they talk about them being limited to using the documents for their regulatory purposes. And that may be a nod towards this no infringement principle, because the whole foundation of that is that the documents can only be used for the regulatory purpose, and because that supposedly doesn't affect the client. That's said to be the foundation. So they're the possibilities. I don't know whether Andrew, from his experience of actually dealing with the SRA, is able to shed any light on what he thinks they might be getting at.
That's right. At my previous firm, I actually acted for the SRA, so I do have some experience of sort of privilege arguments coming up, or respondents, initially at least, responding to notices saying, no, we're not having this as privileged. And certainly back then, this was quite a few years ago, it was very much the Parry Jones, Morgan Grenfell, no infringement line that was taken. But again, I know you're about to talk about some more recent cases, which potentially put that into doubt. But certainly back then, that was the position that they were taking to requests, to pushbacks like that.
So Adam, are you saying in 2025 there might be some weakness in the SRA's reliance on that Grenfell line?
Yeah, so I think it's more than that, and this is a topic which is of some interest to me, because this point arose in a case that I was involved in about 5 years ago, where we lost at first instance in front of Mr. Justice Arnold, but won in the Court of Appeal. And it wasn't a case about solicitors at all. It was the Financial Reporting Council, which is the regulator for accountants and auditors. And essentially what had happened is the FRC had served a notice on Sports Direct, the sports retailer, asking for various accountancy-related documents. Now, they wanted them for the purposes of an investigation into Sports Direct's auditor. And Sports Direct refused on the basis that some of the documents that they were seeking were privileged. And eventually the FRC took legal action against Sports Direct, and they said that even if you're right that these documents are privileged, it doesn't matter, because we can rely on this no infringement principle. And as I mentioned, at first instance, Mr. Justice Arnold agreed with the FRC and said this principle applied. And my client, Sports Direct, appealed, and we won 3-0 in the Court of Appeal. And the Court of Appeal went back to, certainly in my view, is the orthodox position, which is this no infringement principle doesn't exist. And in fact, recognizing it would make quite serious inroads into pretty core principles of legal professional privilege. So the upshot of that decision in Sports Direct and the FRC is that there is no, at least beneath the Supreme Court, there is no infringement principle anymore. And so if that's what the SRA is intending to rely upon, I think it's pretty clearly wrong. And indeed, this has come up not in England, but in Scotland, where there is a different regulatory regime for solicitors. There's a sort of split between the disciplinary side and the complaints side. But the Scottish Legal Complaints Commission was involved in a case in Scotland a few years ago where this point arose about whether they could access client privilege material. And the inner house of the Court of Session rejected reliance on this no infringement principle. They followed the Court of Appeal and Sports Direct and said no such principle exists. So that's, of course, not the end of the story, because we still have the other option, which we mentioned, which is statutory override. So that is at least a theoretical possibility. The difficulty is that Section 44B doesn't say that a solicitor must produce documents even if they are privileged. If it said that, we wouldn't be having this discussion. It would be perfectly clear. So the real question is, can the SRA argue for necessary implication? And as I mentioned, that's a very stringent, very demanding test. For my part, I'm quite skeptical that they could satisfy. And I think it's worth mentioning that there are other powers, as Andrew will know, that the SRA has, for example, to intervene in a firm. And I think if that's the context, the argument for necessary implication is quite strong, because I don't see how the SRA can take over a firm and effectively step into the shoes of the firm and run it without then being able to see any of the documents. So that, to me, strikes me as a case where you could argue pretty cogently this is a necessary implication, the whole regime would work. But I think it is far from clear that that is equally true of the Section 44B notice regime. So I think this is very much something to be determined in the future if we have a case where someone raises this point.
Andrew, are you seeing this addressed in practice in investigations, if not in the firm takeover scenario?
Well, I think in practice, the issue is often dealt with through client consent. And then after that, if there isn't any client consent, in the rare cases where that happens, I think firms generally are, my impression, providing the material. And I think that's quite often because, as Adam mentioned at the outset, they may well have an interest in providing the material if it helps show that they advise their client properly. Now, whether they should be taking such a casual approach is another matter, but I guess the incentive isn't really there at the moment for them to challenge it, because they're being told by their regulator, you have an obligation to provide this material. They might consider it in their obligations to comply with that request. So I guess what you would really need is a client who was adamant that that request shouldn't be complied with, or a firm that really wanted to sort of test the SRA's position and take the point to flush this out, and for actually there to be a sort of a binding decision on this, and that just hasn't happened yet.
So we're waiting for our test case. What about then the situation where the advice is about this very matter, where we're talking about advice about a firm's regulatory position?
Yeah, so if the firm is dealing with this request and they take advice on how to respond to that, or they take advice in respect of the SRA's investigation more generally, then that remains privileged. Obviously, the SRA wouldn't be able to see what the other side of solicitors were telling them in relation to an ongoing case. We do sometimes still see issues there. For example, we might advise a firm or an individual on whether they have an obligation to self-report a matter to the SRA. And then a few months down the line, the SRA might become aware of the matter and say, well, why didn't you report this at the time? The individual firm might want to say, well, we took advice at the time and we were advised by our lawyers that it wasn't reportable, and here it is, effectively waiving privilege in the advice that we've provided. And generally, I think that should be only done with extreme caution, because waiver of privilege is quite hard to do. It's quite hard to cherry pick what you waive and what you don't waive. You could end up with a more general waiver or wider waiver than you intended. I think generally the way we would advise individuals or firms to respond there is to say, yeah, we took advice which is privileged, and maybe then to summarize the key points, but not to actually waive privilege in the advice given itself.
And so in terms of how we can develop this area, or how you think it should be developed or will be developing, Adam, do you want to start, given you've got some ideas, I think?
Sure. So I really defer to Andrew as to the sort of practical reality on the ground of how this is dealt with, and perhaps why it doesn't seem to have come up. But I think I had two sort of thoughts about this. The first is, I think we need to recognize, as Andrew's mentioned, that this is an area where there is a potential tension between the interests of the solicitor and the interests of the client. Because it may often be the case that the solicitor is quite keen to explain to the SRA the advice that they gave, because that will actually help their position. And in many cases, it may be the clients are happy to facilitate that by waiving. But if the client doesn't want to waive for whatever reason, or maybe the client's not contactable, you're not able to get a waiver from them, then as a matter of law, the position is pretty clear. The solicitor is stuck with that. And one of the things which I think is slightly unsatisfactory about the current position is that this is an area where the solicitors really need to focus on their kind of overriding duty to their client and to put that duty before their own interests. And you'd think the regulator would also, in other circumstances, the regulator would be very focused on that sort of situation. But this is a bit different because the regulator obviously has its own interest in obtaining these documents. But it seems to me that it's this sort of situation where there's this tension, where these rules are even more important. And the second one is to say that overall, my view is that the current position of the SRA is dubious. I don't think it's unarguable that there's a statutory override, but I'm far from convinced it's right. And if you ask me personally, I think my view is it's wrong. But one of the interesting consequences of the fact that they're at least arguably wrong is that the solicitor arguably has a duty to take this point. Just to explain that, there have been cases where, for example, outside the context we're talking about, where let's say a solicitor is in receipt of a notice, they want to produce documents. It doesn't have to be a regulatory investigation, it could be disclosure. And sometimes the solicitor can't contact the client. And so they can't ask the client whether they're happy for these documents to be produced. And the line that's been taken is that the solicitor is obliged to take all conceivable points to try and defend the client's interests, even if the client isn't there to give them instructions. So the default position essentially is take any arguable point to defend the client's position. And that's what your obligation as a solicitor is. So I think there is a credible case to say that if you are a solicitor on the receiving end of a notice and your client either refuses to waive or you're just not able to obtain a waiver, you just can't find them, that you're actually professionally obliged to say to the SRA, I'm sorry, you can't have this, because I think it is a perfectly plausible, properly arguable position to take that you're not. And if you want these materials, then you're going to have to take me to court to do it. Now, I suspect that has not happened as of yet because we haven't seen any of these cases. But it would be an interesting assessment if, in fact, not only do clients have or solicitors have the option of doing this, but it might be said they have the duty to do it. So that's very much looked at from the perspective of someone very interested in the law of privilege, but very inexperienced in regulatory investigation. So I'd be very interested to hear Andrew's take from someone at the coalface of these investigations.
Yeah, well, I think it's been such a fascinating discussion, precisely because the impression I get from the SRA is that they do consider it to be a settled issue. If you look at the guidance that I referred to at the outset of our discussion, they both came into effect in November 2019 when the Code of Conduct was updated. Hasn't been updated since then to take into account the case that you were involved in or any subsequent cases. We don't have any cases where they're receiving pushback, possibly for the reasons that we both mentioned, in terms of perhaps there being no real incentive for either side to want to sort of rock the boat. So I think what we really do need, as I mentioned, is someone to have pushed back. And I think what you've raised a really interesting point here is our firms just going along with this too readily. And should we be sort of examining or at least putting the SRA's position under more scrutiny when requests like the ones we get typically are received? So I think that will be how it develops ultimately. Because at the moment, as I say, it doesn't seem like the SRA consider they're under any pressure to try and justify their decision based on the developments in the last few years, because they haven't even considered it necessary to update their guidance.
Right. Well, Adam, Andrew, absolutely fascinating discussion, and thank you for the call to arms. I feel like we haven't had one of those for a while in the ReguLaw podcast. thanks again, all the listeners as well. We'll see you in the next episode, and we'll put this up on the website with a link to those cases we've discussed. Thanks again.
Thanks for having me on.